Hello friends, in this video we will be discussing about the recent opinion by a constitution bench on a presidential reference under article 143. So let us understand the issue because it is very important topic of polity and also of current affairs, and it can be asked in exam. So let us first understand the issue and also discuss what can be asked in exam. So the main issue is with governor's powers with respect to state bills. And the issue has basically arisen in states which are ruled by the opposition political parties. So basically the Tamil Nadu government, the Kerala government, the West Bengal government, the Punjab government, etc. they have approached the Supreme Court against the lack of timely decisions taken by the governors on bills passed by the state legislative assembly. तो आप जानते हैं कि the state governments they have responsibility to frame laws, and that is done through the state legislative assembly. Bills are passed in the state legislative assembly, but for the bills to become law they have to get the assent from the governor. और यहाँ कई बार ऐसा हुआ है कि गवर्नर्स की तरफ से काफ़ी डिलेज देखे गए हैं. तो इसी को लेकर एक इम्पॉर्टेंट केस was decided by the Supreme Court this year on 8th of April, but the bench was a 2-judge bench जिसने एक डिसीजन दिया in the favor of the state governments. इस डिसीजन के अगेंस्ट में सेंट्रल गवर्नमेंट हैड टू ऑप्शंस, either to go for a review of the judgment or go for a presidential reference under article 143, which is the advisory jurisdiction of Supreme Court. So what the central government decided, it went for a presidential reference. और इस presidential reference पे अब opinion Supreme Court ने अपना दे दिया है, which has practically negated the April 8th judgment of Supreme Court. So now let us try to understand the issue. Now you already know that a bill is a proposed law. यानी कि कोई भी लॉ को जो स्टेट गवर्नमेंट को बनाना होता है या इवन सेंटर में, तो उसको एक ड्राफ्ट लॉ तैयार किया जाता है, उसको बोला जाता है बिल. तो proposed law is known as bill. It is introduced in the state legislative assembly normally by the minister. अब ये जो स्टेट लेजिस्लेटिव असेंबली में इंट्रोड्यूस होता है, इसके बाद इसको पास करना पड़ता है स्टेट लेजिस्लेटिव असेंबली से, और इसमें जनरली आपको जो मेजॉरिटी चाहिए सिंपल मेजॉरिटी. सिंपल मेजॉरिटी मींस मेजॉरिटी ऑफ प्रेजेंट एंड वोटिंग, मेजॉरिटी ऑफ प्रेजेंट एंड वोटिंग, राइट. तो इसको आप ऐसे समझिए, सपोज द टोटल स्ट्रेंथ ऑफ द असेंबली इज से 200, बट फॉर एग्जाम्पल यहाँ जो उस दिन प्रेजेंट हैं वो हैं 120. अब इसमें से वोट कितने लोग दे रहे हैं, दैट इज़ इम्पॉर्टेंट. और इस बिल पे सपोज सिर्फ 100 लोग वोट दे रहे हैं. तो जो मेजॉरिटी हमें देखनी है फॉर ऑर्डिनरी बिल, दैट इज़ नॉट ए मेजॉरिटी ऑफ द टोटल. यानी कि टोटल की अगर हम मेजॉरिटी देखेंगे तो वी नीड एटलीस्ट 101 वोट्स इन फेवर, राइट, क्योंकि 200 टोटल है तो 100 डिवाइडेड बाई 2 + 1, बट दैट इज़ नॉट कंसिडर्ड. प्रेजेंट 120 है तो प्रेजेंट की भी हम नहीं देखते हैं, बिकॉज प्रेजेंट का अगर देखेंगे तो 120 डिवाइडेड बाई 2 दैट इज 60 + 1 61. बट हम देखते हैं प्रेजेंट एंड वोटिंग, यानी कि जो प्रेजेंट भी है और वोट भी कर रहे हैं, तो इसको हम बोलते हैं प्रेजेंट एंड वोटिंग, एंड विच इज़ 100 हियर, दिस नंबर. तो 100 का मेजॉरिटी जो है दैट इज़ 100 डिवाइडेड बाई 2 + 1 दैट इज़ 51. तो 51 मेंबर्स नीड टू वोट इन फेवर. प्रेजेंट एंड वोटिंग का हम देखते हैं सिंपल मेजॉरिटी. सो द बिल इज इंट्रोड्यूस्ड विच इज़ प्रपोज्ड लॉ, स्टेट लेजिस्लेटिव असेंबली में आता है, एंड द स्टेट लेजिस्लेटिव असेंबली हैज़ टू पास इट विथ सिंपल मेजॉरिटी. वंस इट इज़ पास्ड विथ सिंपल मेजॉरिटी, देन इट रीचेज द गवर्नर. गवर्नर के पास पहुंचता है. नाउ गवर्नर के पास कौन सा आर्टिकल है, और कॉन्स्टिट्यूशन सेज कि अंडर आर्टिकल 200 द गवर्नर हैज़ 3 options before him. What are these 3 options? Under article 200 governor can say yes. Yes is also known as assent. ठीक है, in the language of the constitution it is assent. Give assent to the bill. अगर वो yes बोल देते हैं तो the bill will become an act. ठीक है, तो बिल क्या हो जाएगा, एक्ट बन जाएगा. proposed law will actually become a law. The governor can also say no and return it to the legislative assembly. नो बोल सकते हैं और असेंबली में वापस भेज सकते हैं. The assembly can again make some changes and repass the bill. It will again come to the governor, or the governor also has one more option, which is to reserve it for the president. President के लिए भी रिजर्व कर सकते हैं if the governor feels that it touches upon certain things on which the president should decide. तो ये ऑप्शंस हैं अंडर आर्टिकल 200. अब प्रॉब्लम क्या हो रही है कि गवर्नर इज एक्चुअली नॉट टेकिंग डिसीजंस. तो गवर्नर इन ऑप्शंस तक आ ही नहीं रहे, वो यहीं रुक जा रहे हैं. दे आर वेटिंग, दे आर कीपिंग, एंड इट इज़ नोन एज पॉकेट वीटो. तो उन्होंने अपनी पॉकेट में डाल के रख लिया बिल को. और इस चीज़ से क्या हो रहा है कि जो स्टेट का लेजिस्लेटिव प्रोसेस है दैट इज़ गेटिंग फ्रस्ट्रेटेड. एंड बिकॉज ऑफ दिस मल्टीपल स्टेट गवर्नमेंट्स, and mainly these are opposition ruled state governments, they have approached the Supreme Court. Now what has happened? The opposition ruled state governments, they have been alleging that the governors are keeping the bills passed by state legislative assembly pending for a long time without taking any decision. तो इससे जो legislative process है state का वो frustrate हो रहा है. And they have also approached the Supreme Court. और जो April 8 judgment था, that was basically on an appeal filed by the Tamil Nadu government against the governor for not taking decision in a timely manner. Now what did the 8th April judgment decide? Now constitution does not give any timeline, यानी कि constitution में कोई timeline नहीं बताई गई है कि governor has to decide on any bill presented to him within such and such time period, right? तो इसको बोला जाता है constitutional silence. So there is constitutional silence. That means constitution is silent on how much time the governor should take while deciding on any state bill presented to him. So what the two-judge bench of Supreme Court, which was hearing this case, it decided, it's number one, fixed a timeline for governors and president to take decisions on bills passed by state legislative assembly, and the timeline given was 3 months. That within 3 months the governor and president should take a decision, right? Second thing that they decided was that the decisions taken by governor and president on such bills are subject to judicial review. That means the court can review it. Even the fact that the governor is taking a long time और president is taking a long time to decide, वो भी judicial review में आता है. Judicial review means the court can actually take cognizance of this and decide on it. तो judicial review भी बोला गया कि decisions taken by governor and president on such bills are subject to judicial review. Third important thing that the April 8th judgment did, it said that जो बिल्स बहुत ही लंबे टाइम तक तमिलनाडु गवर्नर के पास हैं और एसेंट उनको नहीं दिया गया है बाय द गवर्नर, हम उनको दे रहे हैं, यानी कि कोर्ट हैज गिवन एसेंट. सो अ न्यू कॉन्सेप्ट वाज गिवन बाय द कोर्ट व्हिच इज डीम्ड एसेंट, राइट? डीम्ड एसेंट कि अगर गवर्नर ने एसेंट नहीं दिया है तो हम अपने पावर्स को यूज कर रहे हैं अंडर आर्टिकल 142. सो दिस इज an extraordinary power of Supreme Court to do complete justice in any case, right? So very important, and this is very often asked in exam. This is the power of Supreme Court to do complete justice. To do complete justice, right? तो ये उन्होंने डीम्ड एसेंट भी दे दिया, टाइमलाइन भी फिक्स कर दी, बोला कि जुडिशियल रिव्यू भी हो सकता है डिसीजंस का, और थर्ड उन्होंने ये कहा कि डीम्ड एसेंट दे रहे हैं बिल्स को. नाउ दिस जजमेंट वाज वेलकम्ड बाय द opposition ruled state governments. They were very happy, not just the Tamil Nadu government but also the other governments which thought that it will serve as a precedent in their cases as well. The center was obviously not happy with this, so the union government had two options. The union government could have gone for a review petition or for a presidential reference. Now here we should know that how the system works. तो जो केसेस होते हैं जनरली दे स्टार्ट फ्रॉम द डिस्ट्रिक्ट कोर्ट्स, on appeal they will reach the High Court, and on appeal they will reach the Supreme Court. So Supreme Court का verdict एक बार आ जाता है तो this is the highest court, right? So final verdict comes. But even here, if a party is not satisfied, then it can go for a review. So a review petition can be filed, right? Even after the review petition is decided and still the party is unsatisfied, then based on certain conditions, a curative petition can also be filed. आप curative petition भी file कर सकते हैं. So this is the normal sequence. So the center could have gone for a review petition. Review petition का भी option था center के पास, लेकिन center chose the option of presidential reference. तो center ने choose किया presidential reference. Presidential reference is under article 143 of the constitution. यानी कि president can seek the opinion of the Supreme Court on any important matter. अच्छा, यहाँ बहुत इंपॉर्टेंट है, इसको बोला जाता है एडवाइजरी ज्यूरिसडिक्शन. दिस इज ऑल्सो नोन एज एडवाइजरी ज्यूरिसडिक्शन ऑफ सुप्रीम कोर्ट. नाउ सुप्रीम कोर्ट कैन ऑल्सो से नो टू गिव इट्स ओपिनियन. यानी कि सुप्रीम कोर्ट बाउंड नहीं है. अगर प्रेसिडेंट बोलते हैं कि हमको आपका ओपिनियन चाहिए एंड प्रेसिडेंट बोल रहे हैं, यानी कि अंडर आर्टिकल 74 वी नो दैट इट इज द सेंट्रल गवर्नमेंट सीकिंग through the president opinion of Supreme Court on any important issue. So Supreme Court is not bound, and Supreme Court can also say no to give its opinion, and this has happened in a very famous case in 1993. So 1993 में राम जन्मभूमि केस में Supreme Court has actually said no. Give its opinion under article 143. तो ये भी आपको याद रखना है. sometimes in exam this question can be asked that on which important case Supreme Court declined to give its opinion under article 143. So Ram Janmabhoomi case of 1993. Another important fact we should note here is that this was the 16th presidential reference so far. Since independence, this was the 16th presidential reference, right? तो ये नंबर भी आपको याद रखना कि 16th था ये presidential reference. Now what happened in this presidential reference? And one more thing that we should remember here is that whenever a presidential reference is made, तो important issue होता है और इसमें कम से कम 5 judges bench बैठती है जो decide करती है. तो it is always a 5 judges bench at least. So it is known as a constitutional bench. So presidential reference is always decided by a constitutional bench of at least 5 judges. At least 5 judges. So this also we should remember. Now, in the presidential reference under article 143, which is advisory jurisdiction of Supreme Court, what it basically says, it empowers President of India to seek Supreme Court's advisory opinion on any question of law or fact of public importance which has arisen. Now, it is not the Supreme Court is not bound to give its opinion, and also the President is also not bound to accept the opinion of the Supreme Court. But because ये Supreme Court की Constitution Bench का opinion होता है, it is taken very very seriously. Now in this particular case, the April 8 judgment के ऊपर जो presidential reference center ने दिया उसमें 14 questions were raised, and the questions were mainly concerning about the article 200 and article 201 and whether the court can prescribe timelines on the president or governor to take a decision where the constitution is silent. So let us see what the opinion has been given by the constitution bench. So number 1, it said that governor has 3 options when presented by a state bill passed by the state legislative assembly. Governor can say yes, that is give assent, the bill will become an act. The governor can say no and return it to the legislative assembly with his comments. Why he is saying no? Third is reserve it for president's consideration. तो ये तीनों ऑप्शन है गवर्नर के पास. नेक्स्ट पॉइंट वाज दैट गवर्नर हैज डिस्क्रिशन इन चूजिंग फ्रॉम द 3 ऑप्शंस एंड नॉट बाउंड बाय एड एंड एडवाइस ऑफ काउंसिल ऑफ मिनिस्टर्स. यानी कि गवर्नर जब स्टेट बिल पे डिसाइड कर रहे हैं तो ही इज allowed to act in his discretion. That means he is not bound by the aid and advice of Council of Ministers headed by the Chief Minister. Third point, the court cannot prescribe timelines. यानी कि जो 3 months की timeline prescribe की थी वो भी उन्होंने हटा दिया. Court cannot prescribe timelines for actions by governor and president. Fourth point was the discharge of functions by governor under Article 200 is not justiciable. But in case of glaring inaction by governor, the court can issue mandamus to governor. Right? Mandamus आप जानते हैं कि एक writ है जिससे court can order any authority to do something or not to do something. तो यहाँ सुप्रीम कोर्ट ने बोला, यानी कि जो कॉन्स्टिट्यूशन बेंच है उसने बोला कि जनरली जो डिस्चार्ज ऑफ फंक्शन बाय गवर्नर अंडर आर्टिकल 200 इज नॉट जस्टिसेबल, बट अगर गवर्नर बहुत ज़्यादा डिले करेंगे, अनएक्सप्लेन डिले होगा, तो जरूर हम मैंडेमस इशू कर सकते हैं. हम गवर्नर को बोल सकते हैं कि आप डिसाइड करिए इस पर. फिफ्थ पॉइंट वाज डिस्कशन ऑफ और डिसीजंस ऑफ गवर्नर और प्रेसिडेंट अंडर आर्टिकल 200 और 201 आर नॉट जस्टिसेबल बिफोर बिल इज इनेक्टेड इनटू अ लॉ. यानी कि जो वो डिसाइड नहीं कर रहे हैं, यानी कि टाइम ले रहे हैं डिसीजन लेने में, वो उस पर पहले सुप्रीम कोर्ट कुछ डिसीजन या उसका जुडिशियल रिव्यू नहीं कर सकता है. वंस अ डिसीजन हैज बीन टेकन देन ओनली जुडिशियल रिव्यू कैन बी डन बाय द सुप्रीम कोर्ट, ये भी बोला गया है. तो जुडिशियल रिव्यू इज पॉसिबल ओनली आफ्टर अ बिल इज इनेक्टेड इनटू अ लॉ. एंड आर्टिकल 200 is the 3 options with the governor when presented with the state bill. Article 201 gives the options which are available with the president when presented with the state bill. और president के पास क्या option होते हैं? To say yes, to say no, or to return the bill to the state legislative assembly. Now 6th point was power of Supreme Court under Article 142, which is the extraordinary power to do complete justice, cannot substitute the power vested in governor and president under the constitution. Therefore there is no concept of deemed assent. तो जो deemed assent दिया गया था तमिलनाडु के बिल्स को by the Supreme Court with its April 8 judgment, उसको सुप्रीम कोर्ट ने कहा है कि ऐसा कोई कॉन्सेप्ट deemed assent का नहीं है and the court cannot do it. So the April 8 judgment was in favor of the state governments, but now the presidential रेफरेंस में जो ओपिनियन आया है उसने करीब करीब उस चीज़ को नेगेट कर दिया है. तो व्हाट इज द बेसिक इशू दैट वी नीड टू अंडरस्टैंड हियर? तो बेसिक इशू इज अबाउट द पॉलिटिसाइजेशन ऑफ द ऑफिस ऑफ द गवर्नर. एंड द गवर्नर इज अ वेरी इंपॉर्टेंट पोजिशन इन इंडियन फेडरल पॉलिटिकल सिस्टम. नाउ द गवर्नर हैज 2 roles as agent of the center and the constitutional head of the state. Ideally, there needs to be a balance between the two, but we are seeing that in recent times the tilt is more towards acting as agent of the center, and that is leading to this conflict with the opposition ruled state governments and the governor. So this is a very important topic, and we should definitely expect questions on this, right? The articles concerned and also what the court has decided in its presidential reference opinion. Now there's one question for practice which you can attempt. I'll just read out the question and you can maybe write your answers in the comments. So you have to match the articles correctly with their description. The articles given are A143, B142, C200 and D201. The descriptions are as follows. One says extraordinary power of Supreme Court to do complete justice. 2 is advisory jurisdiction of Supreme Court. 3 is options available with President when presented with the state bill reserved by Governor. 4th is options available with Governor when presented with a bill, right? So you have to select the correct options, A or B. You can write your answer in the comments. So this is it for this video, and I'll see you in the next video. Thank you.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.